exchanges, energy, and credit entitled Brexit and Other International Developments Affecting the U.S. Derivatives Market will now come to order. And I want to thank everyone for joining us this morning. This is a very, very important hearing. The very future of our international financing, cross-border financing, is very critical because of what's happening concerning Brexit. So today we really want to examine it very thoroughly so we come to a very succinct understanding with supreme knowledge as to how the situation involving the European Union's divorce with Great Britain affects our United States financial industry. It is most important that when we leave this hearing today, we will have one resolve, and that is to make sure what is happening with Brexit and the European Union does not, will not, and cannot put our United States financial industry in a weakened position. It is important that the United States financial industry remain in its position as the most significant, most important, most influential financial system in the world, because the world is depending on that and us making sure of it. There are some threats out there with this move in Brexit. And that's why we in this committee realize our responsibility as members of Congress to hear from you, to hear from our market participants, for you are the ones that engage in this. And we've got to remember that this is an $843 trillion, not million, not billion, but trillion-dollar piece of the world's economy. And let me assure you that the United States financial system must remain number one in this strengthening position. Now, there are some very important facts I want to go over so you can see where we are. First of all, as we look at Brexit and other international developments, we know without a doubt that there are 27 members of the EU that are bracing for Great Britain's exit from the Union. And the UK approaches a leadership crisis within its Prime Minister's departure, and she is still at the helm, but there are so many things that are bubbling up underneath. Now, it's important for me to share with you that in 2016, the CFTC completed, that's the Commodities, Futures, and Traders Commission, completed a 3-year negotiation for an equivalence agreement. It's very important to note that prior to this point, it was the European Union that was our equivalency partner. And this agreement on the regulatory treatment of derivatives clearinghouses with the European Union. And this agreement ensured that both the EU and U.S. clearinghouses operate at the same high standards and at a comparable level of cost to their participants. Last year, As the EU prepared for the potential impact of Brexit, the EU Parliament passed the European Market Infrastructure Regulation, EMIR 2.2. I want to pause there. EMIR 2.2. And we have got to examine EMIR 2.2 thoroughly this morning, because we on this committee are convinced that EMIR 2.2 presents a very clear and present danger to our United States financial industry. When they passed EMIR 2.2, it unilaterally and automatically scrapped the 2016 Equivalence Agreement. EMIR 2.2 increases oversight of the EU and third country clearinghouses, and it has significant implications, as I said, for the industry in the United States. Some of the most extreme parts of this suggested policy is, number one, administrative fees charged to clearinghouses in other countries in exchange for oversight, and we'll get back to that, by the EU. Comparable compliance discounts instead of grandfathering, which means that even when granted, you will get a discount of 15, 20, or 35% of fees. Also, a very complex tiering regime, where the difference between Tier 1 and Tier 2 is fees that are as much as 7 times higher. Tier 1 is 50,000 euro. Tier 2 is 350,000 euro, 7 times higher. However, the largest concern is a possible relocation provision requiring that all clearing move to the EU, either by the letter of the law or by making it so expensive that companies outside the EU will be priced out of competition. And everyone in this room knows that financial instruments do not operate in a vacuum. What happens in the EU and the UK will ripple through financial markets, just as our decisions here in our country have ramifications for them. So it is my hope today that with our discussions and conversations that we will have today, that we can begin to explore and better understand what Brexit and the associated geopolitical developments in Europe and elsewhere will mean for the derivatives market in the United States. And with that, I would like to now recognize my ranking member, the other distinguished Mr. Scott from Georgia, for 5 minutes.
Thank you, Mr. Chairman, for convening this hearing. You and I share a deep concern over what I would refer to as the potential absence of international harmonization work between the CFTC and their global counterparts. The main focus of today's hearing is the impact of Brexit in U.S. derivatives markets. But we can't talk about that without discussing the European Commission's potential divergence from what was a hard-fought 2016 equivalency agreement. For years, this committee has been focused on the importance of harmonizing our international response to the financial crisis. And we, when Chairman Gensler sought to impose the U.S. swaps dealer rules around the world, we pushed back because we rightly believed that overlapping rules would make it more difficult or impossible for global risk markets to function as end users and other market participants need them to. Today, we're in a similar place, except instead of making common calls with our European colleagues, we're having to have another discussion about what I thought were principles that we had agreed on, principles that were agreed on with people who share both our interests and our values. Implementing EMIR 2.2 in a way that would disrupt our existing equivalency agreement would trample on our previously shared principles. Just like in 2011 and 12, regulators are playing a dangerous game, trying to expand their reach into places that are already well regulated. Such an effort, just as it was going to then, will result in inevitable conflicts, legal uncertainty, and other challenges for market participants. When there is uncertainty, there will be less liquidity. And when there is less liquidity, there is more risk for those who are driving our economy. We need our regulators to work together to preserve our open global markets while building the compatible standards that protect market participants and encourage financial stability. Open markets and financial stability should be our goals. Regulators should seek to implement rules that promote both. Our U.S. prudential regulators could also remember this lesson from time to time. The capital standard and margin rules that they've been working on are both out of step with the global norms and do not promote access to clearing or sound hedging practices. The capital rules treatment of initial margin and unmargined commodity derivatives both penalize end users who will see reductions in access to cleared market intermediaries and increase the cost for utilizing their right to opt out of the margin requirements. Our prudential regulators insist on requiring margin for internal swaps that transfer risk within the same bank holding company, present similar problems for end users. Ultimately, the cost of moving risk within a bank to the place that it's most economical is the cost of providing a service to a client. If we make the services more expensive, it won't be the bank that pays, it will be the bank's client, the end users who rely on the services that pay. They will either pay in money or they will pay in loss of access. These requirements in both rules run contrary to the spirit and intent of our committee commitment to end users that when we enacted the law. I'm happy to note the commissioners are examining changes that will improve coordination and harmonization. I hope their efforts bear fruit, and I hope our European colleagues will join them. Mr. Chairman, I will end with this. The first meeting I was in this morning, a gentleman said, do you want to beat people or win people? What we want in the harmonization with the regulators is a win-win situation for all of us who have shared interests and shared values. And if we don't have that, my fear is that it will be other countries who control the trading who don't share either our interests or our values. Thank you, Mr. Chairman, for having this meeting.
Well, I certainly agree with you, Ranking Member. And now I'd like to recognize our distinguished former chairman and now Ranking Member, Mr. Mike Conaway.
Thank you, Mr. Chairman, and I agree wholeheartedly with what you and the Ranking Member both have said during your opening statements. I certainly appreciate that. I know that you both remember the hearing that we conducted in 2012 on international regulatory harmonization. It was a good and informative hearing, and I expect that today's hearing will build on that work. I was looking through the transcript of that hearing in preparation for today, and I'd like to share some words of wisdom submitted by Chairman Stephen Mayor, who was then and still remains the chairman of the European Securities and Market Authority, or ISMA. In written testimony, he summed up the issues we're talking about today quite well. At the time, he wrote, "A number of conflicting, duplicative, and inconsistent requirements have been identified when analyzing the simultaneous application of different national regulations. These requirements, if applied on a cross-border basis to the same entities and transactions, would, in certain cases, impede a transaction from taking place or might impede an entity from operating with United States counterparts. This would have serious consequences for global market liquidity and might even have financial stability consequences. ISMA considers it to be of fundamental importance to avoid the application of two or more sets of rules to the same entities or transactions, if those entities and transactions are subject to appropriate requirements in their home jurisdiction. Therefore, we urge U.S. regulators to rely on the maximum extent and equivalent requirements enshrined in EU law instead of imposing U.S. requirements when those non-U.S. entities are dealing with U.S. persons. When a duplicative application of rules cannot be avoided, we believe it is essential to identify and mitigate any possible conflict that might arise from that situation. As Ranking Member Mr. Scott mentioned at the time, you and I and this whole committee argued strenuously against our own U.S. regulators when they sought to push the boundaries of our regulations too far. We were worried about exactly what Chairman Mayor identified: duplicitous and inconsistent requirements, harming global liquidity formation, and raising financial stability concerns. Yet today, it is U.S. regulators who are recalibrating their approach and working to offer solutions to these thorny cross-border issues, and our European colleagues who are failing to heed their own advice. If European regulators persist down this path, we will likely learn that they were correct in their analysis and find that their actions have left our global markets in disarray. Mr. Chairman, before I close, I want to mention my deep disappointment in comments made by a senior Commission official at a conference several weeks ago in London. It is particularly personal to me because you and I so warmly received his testimony on this topic during that December 2012 hearing. In their worst light, his comments suggest that the United States does not have a partner, but a competitor in financial market regulation, a competitor who is willing to use its regulations to its strategic advantage. Viewing financial regulations as a competition would be a grave mistake. But even in their best light, his comments betray a smugness that is inappropriate among friends. Such casual arrogance breeds mistrust, frustration, and needless friction at a time when we cannot afford intramural sniping. I've been struggling to make sense of the complete reversal of principle from our European friends expressed at their 2012 hearing. It's comments like these that lend credence to the argument that our ongoing CCP equivalence disagreements have nothing to do with systemic risks or safety and soundness of European institutions and everything to do with retribution and competitive regulatory arbitrage. I certainly hope that's not the case. If it isn't, European leaders should plainly make that clear through their words and their actions. And with that, I yield back.
Well, Ranking Member Conaway, thank you so much for that. And as you know, I agree with you 100%. And I really appreciate you really exposing that to the committee this morning.
Thank you, Mr. Chairman.
Thank you very much. And now the chair would request that other members submit their opening statements for the record so the witnesses may begin their testimony and to ensure that there is ample time for questions. And let me begin now by welcoming all of our distinguished members and thanking you all for coming, and we're looking forward to your testimony and this important issue. First of all, Mr. Terrence Duffy, thank you for coming. Mr. Duffy is Chairman and CEO of the CME Group, Chicago Mercantile Exchange in Chicago, Illinois. Thank you for coming, sir. We also have next Mr. Christopher Evans. Mr. Edmonds is Senior Vice President, of Financial Markets for the Intercontinental Exchange, Chicago, Illinois. Wonderful. And please give my regards to Mr. Jeff Spector, a good friend, and ICE, as you may know, is located in our wonderful, headquartered in our wonderful state of Georgia in Atlanta. Thank you. And next we have Mr. Daniel McGuire, who is CEO of the LCH Group, London, United Kingdom. Thank you for coming. And we really appreciate you coming over the pond to deal with this very important issue that London and Great Britain are grappling with at this moment. Thank you for bringing that insight to our subcommittee meeting. And next we have Mr. Walt Lucan, who is the President and CEO of Futures Industry Association, Washington, D.C. We're very much looking forward to your comments as well. And finally, we have Mr. Stephen Berger, Managing Director of Global Head of Government and Regulatory Policy, Citadel LLC, on behalf of Managed Funds Association out of New York, New York. Good to have you. Thank you. We look forward to your input as well. What a distinguished panel. Thank you all very much for coming. And now we will now proceed to the hearing from our witness Each of you will have 5 minutes, and 1 minute is left. When that is, the light will turn yellow, signaling time is closely expiring. However, this is indeed a very critical and important hearing, and if there's something else that is pressing that you need to be said, the chair will be lenient to make sure your full thoughts are here, because you are the ones who are out there day in and day out within this as leaders of our financial system in this international marketplace. And we want to make sure that we hear from you and your recommendations as to what recommendations we need to take as a committee to make sure your positions at the world market are strengthened and you are not weakened on the world financial stage. All right? So we'll hear from you first, Mr. Duffy.
Well, thank you, Chairman Scott, Ranking Member Scott, and members of the committee. I'm Terry Duffy. As the chairman said, I'm the Chairman and Chief Executive Officer of CME Group. Before I go into some of my prepared remarks that I wanted to give to you today, I'm absolutely struck by what I heard here by this Congress. And I want to thank you, Mr. Chairman, for your leadership, Ranking Member Scott, for your leadership on the comments that I heard. And Mr. Conaway, what you had said is just so profound to dig back up what people said in 2012. It's just truly amazing that we're sitting here today in the duplicitousness of what people have said throughout the time. And I don't think a lot of people understand the importance of this committee, what it's doing here today. And so, Mr. Chairman, I really applaud your foresight to bring this forward, because you look at what's going on in the world today alone, just with the farm community. And not only are they dealing with very difficult issues as far as trade goes, they're also dealing with extremely difficult issues with weather. These are a couple issues that they have no control over. But to your point, Mr. Conaway, the liquidity, or Chairman, Ranking Member Scott, on the liquidity, this is critical. This Congress has an opportunity not to impose another problem for the American farmer, and that is giving them a place where they don't have any risk management tools during these very uncertain times. And if you think that there's nothing else to it but agricultural products, you could talk about home mortgages. You could talk about fuel for your car. You could talk about your 401k. All these different services that we use in our daily lives need risk management products. And if you drive the cost up, I think Mr. Conaway said, it will fall on the consumer. That's where it ultimately goes. So your foresight to have this committee is critically important. It's a lot more than just regulatory arbitrage. This has a lot to do with the American consumer and the global consumer. So I really applaud your efforts, all of you in this committee, for going forward with this. That being said, I testified before the subcommittee almost 3 years ago to the day in June of 2016. After that hearing, I stated the negotiations between the United States and the European Union on equivalence were successfully resolved in February, when the European Commission officially granted the CFTC equivalent status. I encourage global regulators to avoid potential market disruption in the future by implementing long-term solutions. And I warned, if this is not the case, regulation will artificially influence liquidity, price discovery, and risk management, and competitively disadvantage individual markets in an increasingly competitive global marketplace. Unfortunately, here we are 3 years later, again discussing a regulatory overreach by the European Union that is in direct challenge to the authority of the United States Congress and the Commodity Futures Trading Commission to set rules and to regulate the U.S. futures market. 1 year after the U.S. and the European Union reached the equivalence agreement in 2016, in the wake of Brexit, the European Union proposed legislation creating a sweeping new set of regulations to apply to clearinghouses operated outside the European Union. This new law, as the chairman referred to it, is a mere 2.2, unilaterally amends the agreement, layering significant new requirements on top of those previously agreed to without justification. The 2016 agreement was the result of painstaking comparison of U.S. and European Union clearinghouse regulations. Its ratification reflected consensus that the U.S. regulations were comparable and equivalent to those in the European Union. Yet, just last month, as the chairman said, ESMA and the European Union Regulatory Authority they were tasked with overseeing the non-European Union clearinghouses, released its consultations detailing how they recommend implementing the new EMIR 2.2 requirements. The consultations propose to needlessly require a line-by-line comparison of U.S. and European Union laws, ignoring the principles of deference and substituted compliance that the two jurisdictions agreed to just a few years ago. ESMA proposed to classify U.S. clearinghouses according to their systemic relevance to the European Union through a set of subjective criteria that in many cases have no nexus to the European Union and are inappropriate tests of whether a U.S. clearinghouse has systemic importance to the Union. ESMA further proposes to override U.S. law and the 2016 agreement by rejecting substituted compliance for U.S. clearinghouses that they deem systemically important to the European Union. ESMA proposal would demand strict compliance with the majority of the European Union rulebook, effectively making ESMA, instead of the United States Congress and the CFTC, the standard setter for U.S. clearinghouses. ESMA would also give European Union regulators authority over clearinghouses' corporate governance. This is in direct conflict with U.S. law and imposes fees on U.S. clearinghouses to fund the European Union's expansion of its regulatory apparatus. This wholesale regulatory takeover by the European Union is inconsistent with the needs of global financial markets. Without deference and cooperation, global markets will face regulatory fragmentation, resulting in, as we said earlier, decreased liquidity, increased volatility, and higher prices for all market participants and ultimately consumers. It will place a higher cost on farmers, end users, and producers that use U.S. markets to hedge risk. If this European Union legislation were to be enacted, it will weaken the stability of the U.S. financial system, in addition to the global financial marketplace. Our U.S. regulators have long-standing experience overseeing complex markets, ensuring robust risk management, and assessing systemic risk. Rather than attempting to override this capable and vigilant regulatory regime, the European Union regulators should work with the U.S. to build a coordinated global regulatory framework. Mr. Chairman, members of the committee, I thank you for giving me the extra time to give my comments today. I look forward to answering any questions you may have.
Thank you very much, Mr. Duffy. That was very informative. And now I recognize, I don't know, what did Mr. Edmonds. Sorry about that.
Chairman Scott, Ranking Member Scott, and members of the subcommittee, I'm Chris Edmonds, Senior Vice President for Financial Markets, Intercontinental Exchange, or ICE. I appreciate this opportunity to appear before you today as this committee looks at Brexit, EMIR 2.2, and related cross-border issues. Central counterparties play a critical role in financial markets, serving the needs of market participants around the globe. Policymakers across the world, including this committee, have an interest in safe and efficient markets. Since launching an electronic marketplace for energy in 2000 in Atlanta, Georgia, ICE has expanded in both the U.S. and internationally. We have acquired or founded derivatives exchanges and clearinghouses in the U.S., Europe, Singapore, and Canada. In 2013, ICE acquired the New York Stock Exchange, which added equity and equity option exchanges to our business. Today, ICE owns and operates 6 geographically dispersed clearinghouses that serve global markets and customers across North America, Europe, and Asia. Each of these clearinghouses is subject to direct oversight by local national regulators and subject to regulations reflective of the G20 reforms and IOSCO principles. Our assets are regulated by the CFTC, the SEC, the Federal Reserve System, the Bank of England, the UK Financial Conduct Authority, the European Securities Market Authority, the Monetary Authority of Singapore, among others. So over the last decade, we have become familiar and worked closely with global regulators to understand their unique perspective. Clearing has consistently proven to be a fundamentally safe and sound process for managing systemic risk. Observers frequently point to non-clear derivative contracts as a significant factor in the broad reach and complexity of the 2008 financial crisis, while noting the relative stability of cleared markets. Regulators and market participants also understand these are global markets, and to realize the goals of G20 reforms, it is essential regulators share information and continue to cooperate with each other, consistent with agreed-upon international frameworks. As an example, ICE supports the ongoing dialogue between the European and U.S. policymakers where there have been notable success. The 2016 agreement between the European Commission and CFTC established a common approach to supervision of cross-border CCPs. This agreement promotes regulatory deference as well as prioritized provisions supporting robust global derivative markets. Continued regulatory cooperation is imperative as issues such as Brexit, which should have no bearing on these efforts, are determined by other political bodies and agendas. Differences in unsubstantiated changes in financial sector reforms can lead to overlapping and conflicting requirements. This is in no one's best interest, and it's been clearly articulated here today in previous comments. The spirit of cooperation should guide our ongoing discussion on critical cross-border issues, including EMIR 2.2 implementation and potential Brexit responses. The proposed EMIR 2.2 text contemplates that with respect to non-European Union domiciled CCPs determined to be systemically important, ESMA could rely on comparable compliance with the CCP local regulatory regime. However, the text also contemplates that ESMA be able to recommend and the Commission be able to adopt, after agreement with the ECB, an act requiring a clearinghouse to relocate in the EU if the central counterparty or some of its clearing services are of such systemic importance. A better outcome would be to continue the development and reliance on a model of supervisory cooperation, enabling EU supervisors to exercise appropriate and proportionate oversight of central counterparties. The European Commission policy goal is to ensure appropriate supervision of non-EU domiciled CCPs that are deemed systemically important. Completely understandable. ICE believes these goals can be achieved by ESMA employing mechanisms based on international standards such as CPMI IOSCO. Each national regulator should consider the interest of other relevant authorities and interested parties when managing a crisis. However, there should be no ambiguity in the ultimate decision-making authority. For the avoidance of doubt, the industry cannot afford any regulatory confusion in a time of stress. ICE believes the cross-border oversight and regulatory deference to home country regulators are essential to well-functioning markets. They are the foundation of healthy global markets. The CFTC's recent publication and Chairman Giancarlo's description of his vision for future CFTC rule proposals are, in ICE's view, positive steps towards implementing relevant laws, standards, and policies that further the goal for financial stability, resilience while minimizing supervisory duplication and conflict. ICE has always been and remains a strong proponent of open and competitive markets with appropriate regulatory oversight. To that end, we have and we will continue to work closely with this committee and all regulatory authorities to ensure access to all relevant information available. Mr. Chairman, thank you for the opportunity to share our views with you. I'd be happy to answer any questions you or the members of the subcommittee have today.
Yes, thank you very much, Ms. Evans. Appreciate that. And now, Mr. Daniel McGuire.
Chairman Scott, Ranking Member Scott, members of the committee, thank you for your warm welcome and the opportunity to appear before the committee today to discuss the evolving global dialogue on cross-border regulation of clearinghouses, as well as Brexit and its potential ramifications and impact on the wider markets. Some context. I'm Daniel McGuire. I serve as Chief Executive Officer of LCH Group, and I'm a member of the Executive Committee of the London Stock Exchange Group, a global financial market infrastructure business, which comprises of 4,500 employees globally, of which over 700 are here based in the United States. I've been with the firm for 20 years, including several years based in New York during the formative years of Dodd-Frank implementation, during which time I spent a substantive amount of time here in Washington working with the regulators on the swaps rules that were developed and implemented. LCH operates the world's largest clearinghouse for swaps. It's domiciled in the UK, and it's a global business serving global clients. It covers 60-plus jurisdictions in terms of clients, 26 currencies, and has regulatory oversight and direct licenses in 10 jurisdictions. Our home country regulator is the Bank of England. However, LCH has also been registered as a derivatives clearing organization, a DCO, with the CFTC since 2001, for over 18 years now, long before the crisis in 2008 and the Dodd-Frank Act. LCH's interest rate swap clearing service, SwapClear, clears circa 90% of the global cleared interest rate market. Really, to give some context, just as farmers and ranchers may use commodity derivatives to manage their risk of exposure to commodity price fluctuations, it's fair to say U.S. corporations, asset managers, and other end users in the U.S. utilize interest rate swaps to manage their risk exposure to interest rate fluctuations. The interest rate swap market is one of the largest global financial markets, and I'm pleased to provide our perspective on this important piece of the committee's jurisdiction. My remarks today will focus on three topics. First, with respect to Brexit. I'm pleased to say that temporary measures have been put in place to avoid disruption for the interest rate swap markets, regardless of political outcome. 3 years ago, the UK voted to leave the EU. To date, no agreement has been reached for the orderly exit from the EU, and if no agreement is reached by the end of October 2019 and no extension of the current deadline provided, the UK will leave the EU without transitional arrangements in place, commonly known as a hard Brexit. To mitigate the significant market disruption and financial stability risks in the event of a hard Brexit, the European Commission and the UK government collaborated to install temporary contingency measures that would allow EU participants to continue to have access to UK clearinghouses and their global liquidity in the event of a hard Brexit. However, regardless of if there is a hard Brexit scenario or not, LCH will therefore be able to continue offering all of these clearing services. So we welcome these proposals and actions by the European Commission and ESMA, as been referred to by others, which provided great clarity and certainty to market participants in the EU and outside of the EU too. As a systemically important global institution, our main priority continues to ensure the orderly functioning of the markets, continuity of service to our customers, and most importantly, supporting financial stability, regardless of the Brexit outcomes. My second point really comes to the evolving framework regarding large global or international clearinghouses. The future architecture of global derivatives markets must, at all costs, avoid unnecessary fragmentation, and therefore must support a form of regulatory supervisory cooperation and deference mentioned by my other colleagues today. Following the financial crisis in 2008, the G20 agreement in 2009, the US passed derivatives reforms in 2010, and Europe the same in 2012. In 2016, the Brexit vote was shortly followed thereafter by the EU proposed amendments to EMIR that would redefine how clearinghouses outside of the EU would be regulated. This is commonly known as EMIR 2.2. Under EMIR 2.2, in the event of the UK departure from the EU will be treated similar, if not the same, to the US and other non-EU jurisdictions known as third countries in the EU regulatory context. Regulating global markets requires different jurisdictions to agree on the mechanisms to allow national regulatory frameworks to interact on an international level to avoid fragmentation into smaller localized markets, which increases risk and increases costs for the US and their users. My third and final point, systemically important DCOs should be able to deposit their US dollar cash margin in a US central bank account regardless of their domicile. Although LCH does have access to central bank accounts in many of the G20 jurisdictions, it does not currently have that facility here in the US with the Federal Reserve. As the discussion over the cross-border clearinghouse regulation progresses, we believe that is absolutely imperative for central banks to require clearinghouses that manage substantial risks in their jurisdiction to maintain a deposit account for their currency. To be clear, this is deposit accounts for safekeeping of customer margin. This is not and should not be confused with the Fed providing emergency lending in the event of a crisis, often known as a discount window access. Central bank deposit accounts are widely agreed by the industry and regulatory community as the safest option for clearinghouses. And to put this in context, LCH's daily US dollar cash balances for US customers is in the region of $30 to $40 billion. It's important to note that we operate an extensive global collateral management function to ensure safety of margin that it receives. Having access to a central bank account would only enhance that. So in line with the recommendations from the US Treasury Department and others, we would urge this committee and the relevant US financial regulators to further evaluate the important financial stability role that central bank deposit accounts could make and could play for systemically important DCOs such as LCH and others that are here today. Chairman Scott, Ranking Member Scott, and members of the committee, I'd like to thank you again for this opportunity. I apologize for running over, appreciate the opportunity to finish, and I look forward to answering any questions you may have.
Well, thank you, Mr. McGuire, and you have certainly opened our eyes to much of what we really need to be aware of being on site there in London. Mr. Lucan.
Chairman Scott, Ranking Member Scott, Ranking Member Conway, and other members of the committee, thank you for this opportunity to testify. I agree with the rest of the panel. Your leadership on this topic is extraordinarily important. FIA is the leading global trade organization for the futures, options, and cleared derivatives markets. Our mission is to support open, transparent, and competitive markets. I highlight the word open in our mission because open markets allow people access to hedging vehicles around the world, as you can see by the panel here today. Most importantly, to farmers, producers, and manufacturers who are looking to hedge that risk. So open markets are extremely important. And certainly, in fact, this committee earlier this month in a separate subcommittee held a hearing entitled "The State of U.S. Agricultural Products in Foreign Markets." Members of both sides of the aisle agreed that U.S. producers benefit from fair access to open markets. The same holds true when it comes to financial markets as well. The American farm economy benefits from open and fair access to global derivatives markets. Without this access, costs to farmers, ranchers, and producers to hedge their risk would increase. To illustrate the global nature of the derivatives markets, FIA has polled several of its member exchanges, many of them sitting at this table, regarding the percentage of their volume that comes from foreign counterparties. The full results are included in my written testimony, but the survey highlights that, for example, CME Group reports that 42% of its metals contract volume originates in jurisdictions outside the United States. ICE reports that 35% of its volume in agricultural business comes from outside the borders of the United States as well. European exchange, Eurex, has 79% of its volume for interest rate products coming from outside of Germany. These global markets would not have developed without a common sense regulatory approach based on international cooperation. FIA strongly supports the regulatory recognition and deference model that has been the foundation of the futures industry for years. This committee well knows, but the CFTC was one of the first regulators to put in place a cross-border recognition and deference approach, starting with foreign brokers back in the 1980s and foreign exchanges in the 1990s. The approach focuses on whether comparable foreign rules are indeed comparable and achieve a desired outcome, instead of a line-by-line regulatory comparison. As a former commissioner and chairman of the CFTC, I saw the benefits of this flexible regulatory approach to our domestic markets. However, with post-crisis reforms and the Brexit decision, there are concerns that regulators are moving away from the pragmatic approach by imposing direct authority on third country exchanges, clearinghouses, and transactions. And this divergence could lead to conflicting rules and harmful market fragmentation. Europe, of course, as we've been discussing, is beginning to design a regulatory framework without Britain, treating them as any third country nation outside the EU. This will have an impact on all third country nations, including the United States. FIA is closely monitoring recent revisions to the EMIR 2.2 legislation on clearinghouse supervision. This law may require U.S. clearinghouses that are deemed systemic to be in compliance with significant elements of EU law and to be overseen by EU regulators. If implemented without proper deference to U.S. supervision, this law could lead to contradictory requirements, duplicative supervision, and counter-reactions by global regulatory authorities. Indeed, the G20 has market fragmentation as an agenda item for discussion later on this week in Japan. This is of real concern at all levels. The CFTC chairman has announced his intent to strengthen the CFTC's ability to recognize and to defer to home country supervision for certain foreign CCPs. FIA stands ready to comment on both EMIR 2.2 and the CFTC's proposals when they are released to ensure that the proven regulatory deference and recognition approach remains the standard for cross-border regulation. It is imperative that we get cross-border issues right, especially with Brexit looming. The stakes are incredibly high. Without common ground, we may find ourselves with increasingly fragmented markets. That doesn't benefit anyone, especially customers and producers. I want to thank this committee for focusing on this important topic, and I welcome any questions this committee may have.
Excellent testimony, Mr. Luke, and I agree with you 100%. Now we'll hear from Mr. Burgage.
Chairman Scott, Ranking Member Scott, members of the subcommittee. My name is Stephen Berger, and I am the Global Head of Government and Regulatory Policy at Citadel. Citadel is a leading investor in the world's financial markets. For over a quarter of a century, we have sought to deliver industry-leading investment returns to clients including corporate pensions, endowments, foundations, public institutions, and sovereign wealth funds. I'm here today on behalf of the Managed Funds Association and its members, and I'm pleased to provide testimony as part of today's hearing. MFA represents the majority of the world's largest hedge funds and is the primary advocate for sound business practices and thoughtful regulation of the industry. MFA has long supported congressional reforms of the OTC derivatives markets, including central clearing. Central clearing has benefited the derivatives markets by reducing systemic risk, increasing investor protections, and promoting transparency and competition. MFA supports a coordinated global approach to the regulation of clearing. The coordination between U.S. and European regulators on clearing implementation is crucial to its continued success and efficacy. The United Kingdom's anticipated withdrawal from the European Union introduces new complexities for global regulatory coordination. MFA has been engaging with policymakers and regulators to highlight potential regulatory challenges and recommended solutions for the derivatives markets. I will summarize some of these. With respect to clearing, MFA has been a consistent advocate for the central clearing of derivatives transactions. Recently, the EU amended its derivatives regulation, dubbed EMIR, to allow EU authorities to conduct enhanced supervision of non-EU clearinghouses. In extreme cases, it also allows EU authorities to require those clearinghouses to relocate clearing activities to an EU member state. The impact of these changes on the U.S. derivatives markets will depend on how EU authorities choose to implement their new power. The current U.S.-EU cross-border framework relies on the regulatory tools of substituted compliance, equivalence, and deference between comparable regulations. The new EU powers granted by EMIR could affect that framework. Any deterioration in U.S. and EU regulatory cooperation could jeopardize cross-border clearing, which in turn could fragment the derivatives markets. We urge U.S. and EU regulators to work together to develop an agreed approach to cross-border CCP supervision using existing tools. Another international clearing-related concern is the Basel III leverage ratio. The current application of the leverage ratio to investors' cleared derivatives positions is counterproductive and increases rather than mitigates risk. Banks' capital requirements should reflect the risks of their activities. However, the leverage ratio does not currently take into account the fact that with respect to banks' clearing activities, customers post collateral that offsets the bank's clearing-related risks. Recognizing this offset is necessary to ensure that customer clearing remains affordable and that customers have fair and equal access to clearinghouses. MFA was pleased by the announcement last week that the Basel Committee has finally called for an amendment to the leverage ratio to provide that offset. If the Basel Committee's upcoming published standards are consistent with that announcement, we would join CFTC Chairman Giancarlo in his call to U.S. prudential regulators to promptly implement the revised leverage ratio into their rules. Next, with respect to derivatives trading, the CFTC's proposed amendments to its rules for trading on swap execution facilities is also a key area of concern. The proposal could jeopardize the current equivalence framework between U.S. and EU trading venues that was built on shared commitments to impartial access, straight-through processing, and pre-trade transparency. We encourage the CFTC to make the scope of any amendments more targeted. Lastly, the implementation dates of new margin rules for uncleared swaps are approaching. However, these rules are complex and involve significant compliance expenses and resource commitments. In the near term, the CFTC should work with the prudential regulators to provide guidance to help smooth the market's transition. In the longer term, domestic and international regulators should work to recalibrate the regime. MFA has suggested a number of regulatory measures to help avoid significant disruption to the swaps market, such as extending the phase-in timeline. As a final note, I want to reiterate that the successful implementation of clearing in the U.S. and EU has greatly benefited the derivatives market. The coordination between U.S. and EU regulators over the past several years has been critical to achieving the robust derivatives clearing that we see today. It is therefore important for the U.S. and EU to find a path forward on clearing-related issues. We appreciate the committee's oversight of international developments affecting U.S. derivatives markets, and I thank you for the opportunity to speak here today. I would be happy to answer any questions.
Well, thank you. Thank each of you for your very informative remarks and information you relayed. And I certainly at this time want to thank my staff, our Agriculture Committee staff, for pulling such a distinguished panel together. Thank you all very, very much. Now, members will be recognized for questioning in order of seniority for members who were here at the start of the hearing. After that, members will be recognized in order of arrival. So I'll start and put myself for 5 minutes. You know, as I said at the outset, we want to really find out from you what we should do in this situation as members of Congress, what we can do to make sure that there are no impediments. And from each of your testimonies, you have shared with us some impediments, some things that are standing in the way that need to be removed because of this Brexit situation. And so we want you to be frank. We want you to give us some direction in how we can make sure that our market participants in the cross-border are not inhibited by this divorce that is going on, and also this kind of untoward activity that the EU in and of itself is doing that appears to be some sort of power play. And we want to be knowledgeable from you so we can put into action the necessary movements that can help make sure that our market participants, the United States financial industry, are not put at a disadvantage with what is happening with the European Union and Brexit. But first and foremost, I'd like to get the panel's take on what you think about the most recent and timely news from the CFTC. What are your thoughts on the CFTC's announcement yesterday of the creation of a process to terminate the exemptive relief they have offered to foreign firms under their Part 3 rules? We'll start with you, Mr. Duffy. And then I'd just like very quickly to get each of your take on this. The CFTC's move yesterday is very important. Want to kind of find out how you all feel about it.
So I'll save my comments on what you should do. I think that was your original
Sure.
question, but we'll talk about what the question just asked is, what do we feel about what the action was taken yesterday? I think it was very significant for a couple of reasons, sir, because I think it's the first time we've seen a unanimous decision come out of the commission for all 5 commissioners from both sides of the aisle to agree that this is a big issue, not too dissimilar to what we're hearing from your committee here today. So I think that was a very, very strong positive message. And if they were to enact, to take away the exemption of the Part 30, it would make it very, very difficult, obviously, for European brokers to deal with U.S. clients. They'd have a whole host of new hurdles they would have to go under, which in return would be a lot of costs associated with them. So I was very heartened to see that the chairman and the rest of the commissioners put that out for comment, and that is their position. So I think that's a really good, strong starting point.
Very good. Mr. Edmonds, Vice.
I certainly recommend or recognize what they did yesterday was adding a tool to the tool chest they've had. I think on a historical basis, everyone's looked at that as something that would not be touched at that. But now they've been very clear about what they put out there, giving them the opportunity to take advantage of that given certain circumstances once it's warranted. And I think there are going to be a lot of collection of tools that go in the toolbox before we get through this conversation at a holistic level.
All right, Mr. McGuire.
Thank you, Chairman Scott. I'll be brief. I think it's, to reiterate what Chris said, I think it's a tool in the toolbox. I think that's clear. From our perspective, we are clearly a non-US domiciled CCP. It doesn't directly impact us. We operate here, as mentioned in my testimony, under a direct registration model, which we're strong advocates of. So we are fully compliant with all the rules and don't rely on elements of this. What I would encourage, though, I think it's a potential tool in a potential set of circumstances. I think there's definitely a need all round to consider this, how do I put it, to think about not having an arms race and thinking about more cooperation. I think the danger is as things escalate, things could turn into an arms race, and it's very important that we take the temperature down in time. But I understand the motivations for doing the change in the rule.
Right. Mr. Lucan?
Yeah, Part 30 is the regulation the CFTC has to allow U.S. customers access to foreign markets through foreign brokers that are deemed comparable. So their action yesterday was codifying how you would revoke a Part 30 comparability analysis if certain conditions arose. This was codifying, I think, what was already regulatory practice. Again, it's a tool in the toolbox. You know, it is, if you're looking at carrots and sticks, regulators need carrots and sticks. This was a stick. I think, you know, the regulator and Chairman Giancarlo has also talked about some carrots as well, which is we need to get to a more comparable regulatory structure so we don't have to register DCOs around the globe. I'm looking forward to the holistic package that he's planning to put out, both Part 30 yesterday as a stick and hopefully some carrots in the coming weeks.
Right. And Mr. Berger?
Thank you. As you noted, Mr. Chairman, the proposal was voted out yesterday, so MFA looks forward to reviewing and commenting during the public comment period. I would note, seconding what Mr. Duffy said, there was a unanimous and bipartisan vote by the CFTC commissioners to move forward. And as a general matter, I think it's good public policy to codify powers that currently only exist as part of exemptive relief.
Right. Thank you very much. My time is expired on that, but I will make this. Hopefully I'll have a chance, or we may get to it with one or the other. But what I may want to come back on is that I want to make sure that we get back to this EMIR 2.2 and what we in Congress need to do in terms of this. And I've talked with the CFTC, and there may be a move that we have to put in place to retaliate, and we will examine that. And perhaps Mr. Scott and some of the others will get to that. I now recognize the ranking member for his.
Thank you. Thank you, Chairman Scott. And Mr. McGuire, I appreciate your comments about reducing the temperature. I think that would certainly be the desire of the committee and many of the others. Mr. Duffy, you discussed the idea of regulatory sovereignty and how infringement on the CFTC's ability to regulate U.S. domiciled entities could be harmful. Can you expand on the dangers you see when you look at the potential of having two regulatory masters?
Yes, sir, and thank you for the question. First of all, it's against the law for the CME to be in compliance with EMIR 2.2 because under the U.S. Law, the CFTC is our primary regulator and that's it. So we'd actually be in technical violation of U.S. law if we were to be in compliance with EMIR 2.2. That's just for starters. So the answer to that is what do we do? Well, we could not do business in Europe, but that doesn't make any sense for all the reasons that we outlined. Having duplicate costs associated with this, again, I don't think anybody can understand really what that's going to do to the ultimate consumers, and it's not just in the U.S., it's everywhere. When these spreads widen, you know, those costs have to be borne by somebody, and market participants will bear them, and they will bear them in a way that they can widen their spread, so that's how they do it, and that puts the cost on the consumer. So I think that is very damaging. And again, as I said earlier, this is just not agricultural products. This is your home mortgages. This is your 401ks. The illiquidity that you mentioned earlier, sir, that's a big, big issue. So duplicate regulation makes absolutely no sense. And for a company like CME, which is the largest exchange in the world, we have roughly less than 5% euro-denominated products traded in Europe. So how are we possibly deemed systemically important to the European Union when we have less than 5% euro-denominated products? So I think this is nothing more than what Ranking Member Conway said earlier. This is a little retribution from 2010, 2012, but also this can't go forward, and I think hopefully we're past that. I thought we were past it in 2016, so I'm very hopeful that this Congress will be very much involved.
Thank you, Mr. Duffy. And Mr. Edmonds, as you noted, Chairman Giancarlo's recently proposed changes to how it interacts with overseas clearinghouses. How would the changes that he's proposing change the regulation of clearinghouses?
Well, the proposal that is out there now is really more around what we thought we had in 2016 in the agreement and where that's headed. I mean, we've spent the better part of the last 2 decades, Terry will say it's longer, and that's fine, creating a global market. And everything we're doing right now is trying to combat the balkanization of that market and all the costs that come along with that, along the ride. And I agree with Terry's comments of the risk it faces on the widening spread. But Chairman Giancarlo, and what he's trying to propose is to take that down and get them. We know what we do really well here in the U.S. We understand what the Europeans do really well, and to take advantage of that on both sides of that, so we have a very harmonious global financial system. And if we're not going to do that, as you've articulated and as other members of this panel today have articulated, there is a risk of an arms race. And I don't think as any market practitioner that we're looking for that. And if you think about it from a cost perspective, how are we making the market safer? I mean, it's very difficult for either side of the aisle to say the market's safer at the end of the day because we're balkanizing it. And I think that's going to be a challenge for all of us to look at. But if I look at the chairman's comments earlier about what we can encourage Congress to do is make sure not only at the regulatory side, but also on the market operators that we're walking down a path to, one that is comparable. And if we're there, then we can manage a global financial market pretty well.
Would any of the rest of you like to comment on that in the last 50 seconds?
I would just mention risk management. I think the fear, as much as we can talk about costs and access, but during a crisis when when CCP is trying to preserve the safety and soundness of the system, and you have 2 regulators telling you conflicting things, I think that is, to me, the scariest part of this. And we want to make sure that in this deference approach that it's clear who the principal regulator is and who a CCP has to listen to, so they're not conflicted during a time of crisis that could have significant market disruption.
Thank you. Chairman, my time's expired, but it's pretty clear to me the extreme risk and cost that come with not having the harmonization to the U.S., not just the U.S. markets, but the global markets and the end users out there. And that, again, is very, as you know, damaging to the global economy. With that, I yield the remainder.
Well, certainly agree with you, Ranking Member. Excellent comments. And now we'll hear from Ms. Spanberger, please.
Thank you, Mr. Chairman. Good afternoon to our witnesses. I represent Central Virginia, home to farmers and producers across the 7th District of Virginia. And we've touched on some of the risks to global markets that would be created in the event of hard Brexit and some of the steps that might be taken to mitigate those risks. But given the lack of certainty that we have about the future and what we could be facing, I would love to hear from anyone on the panel who would like to comment on this. What could be the possible outcomes and scenarios facing some of the folks in my district? I'm concerned about the farmers who mitigate commodity price risk through future markets that trade on your exchanges, and other constituents from my district who may have pensions that are affected by these regulatory changes. Could you comment on how a soft Brexit might affect U.S. commodity futures and pensions, and how this would compare to the risks of a hard Brexit, and what some of my constituents on an individual basis might face in the future?
Well, this is something that FI has taken a lead on, both in Europe and the United States, on preparing for Brexit. So at the marketplace, we've worked with all of these exchanges and buy-side members at the panel to make sure that during either a hard Brexit or a soft Brexit, that there's transitional relief. So in a hard Brexit, of course, there is no transition. So, but we have received from the Europeans regulatory relief that will allow people to continue to access clearing in a hard Brexit scenario. We're hopeful that the two parties reach a soft Brexit, and there is a long lead time that will allow us to transition to the new arrangement. But I think the biggest fear is just the political risk involved with this, things outside of our control. I think this industry has done a very good job of planning for either a hard or soft Brexit. But there is, during a hard Brexit, they will cause market volatility, most likely. And that volatility could impact prices, including agricultural prices. So I think we've done about as much as we can to prepare for this. But there's certain things we just can't, and especially in a hard Brexit volatility situation.
I will say, Congresswoman, from our standpoint, CME has already set up operations outside of the UK, so we are incurring duplicate cost in order to be in compliance with whatever happens, whether it's a soft exit or a hard one. But I think for the good people of Virginia, the good news is that they will have access to the U.S. clearing entities today, completely uninterrupted, to mitigate their risks as they continue to run their business. So I don't see much of a risk to the people, your constituents, thankfully. But the risk is the liquidity issue that I think we've all talked about, because there is a continuity of liquidity in the ecosystem that could have an impact on prices. But I'm fairly confident that because of some of the moves that we have made and others, that it should be relatively not interrupted for your constituents.
Okay. Thank you. Would anyone else care to respond?
Thank you, Congresswoman. Yes, just
Thank
briefly,
you.
I think we say we're hopeful of a soft Brexit. We're prepared for a hard Brexit, clearly. And to echo comments of others, there's been a lot of great work done by many across the industry to prepare for that. I think really that the area to focus then is on EMIR 2.2, which has been referred to already, which is not specifically Brexit, but is sort of interlinked with that. The outcome of an arms race, the outcome of a lack of harmonization that's been referred to, is that markets fragment. The outcome of markets fragmenting is liquidity splits, therefore supply goes down, demand stays the same, and in very simple first-grade economics, if supply is down and demand is the same, the price increases. So I think certainly in the financial products that we clear, we're not really clearing the agriculture, but things that would affect pensions, loans, 401ks and mortgages and other things. If markets do fragment as a result of EMIR 2.2, we will see an impact to the end user and the customers and the constituents on those financial products.
Thank you very much. My time is starting to get close to running down, but I was wondering, Mr. Berger, if you could comment on the risk that uncleared swaps pose and how well you expect the uncleared margin rules will work to mitigate this risk.
So implementing new margin and collateral requirements for uncleared swaps was a key component of the G20 reforms to the OTC derivatives markets, and we are in the process of phasing that in through a phased timeline that extends into 2020. And I think what the industry has experienced is the last phase includes the largest number of counterparties. So all those counterparties kind of getting ready and getting through the gate is proving to be a little bit of a challenge. So providing some additional time to phase in the buy side would be a welcome development.
Okay. Thank you, and my time has expired. I yield back. Thank you.
Okay, Mr. Crawford, you're recognized.
Thank you, Mr. Chairman. I appreciate you convening this hearing today. Mr. Duffy, I was at the 2012 hearing that Ranking Member Conaway mentioned. At that hearing, Patrick Pearson testified on behalf of the European Commission, raised an important point about the danger of unenforceable regulations. He said, quote, if the European Union were to try and enforce its rules on all of its affiliates in the United States of America, we would be doing two things that are horribly wrong. We would be trying to enforce something we can't enforce in practice. Even worse, we'd be giving the impression that we will be able to enforce it. And if something goes wrong, where will the plane land? Will it land here in the United States or with a regulator in Europe? So that is the thing that we're trying to avoid. We do not afford ourselves the luxury of putting in place a regulatory system that we know we cannot enforce, end quote. Is the EU in danger of putting in place a regulatory system it can't enforce?
I'm not so sure it's in danger of putting in something that it can't enforce. I think what it's doing, it's trying to put something in place to displace you and the rest of the United States and take over as the regulator. So they probably, in today's global market, they probably could enforce it. And I think that's one of the main reasons why we're here today, is because of the concern that U.S. entities are going to be regulated by European oversight, and that will displace the United States Congress and its own government agencies. We think that's the damaging part. So whether they could do it or not is something that yet to be decided, because they haven't done it. So I would not be able to pass judgment on that just yet.
Well, let me thank you for your candor. You indicated this. I do think there's a political dynamic here. I appreciate your candor on that subject, but in the bigger picture here, what we're talking about today, we've heard this recurring theme about liquidity and things of this nature, and quite frankly, what we're discussing here today, if we don't get it right, we're scaring a lot of liquidity out of the market. I have some concerns about my farmers back home who have, over the years, particularly since Dodd-Frank, have been literally scared out of the market, and at the same time, we in this committee have been told we need to move to a market-based system of agriculture support. And what's the market-based system? It would be obviously using the tools that CME offers, and yet farmers are afraid to get in it. There's a liquidity problem, which creates more volatility, which further exacerbates the problem for farmers that have become relegated to price takers. I don't think a local basis contract is a sufficient risk management tool, do you?
Well, I don't know if it's not, but I will tell you that your comments are not on deaf ears. We have worked very, very hard with the community. That is our roots, is in agriculture, as you know.
Sure.
And we want to continue to make sure we provide a level playing field for people to manage the risk in the farm community. We're talking about feeding, 9 billion people by 2050, and the American farmer is a big part of that, but they're not going to be able to be a big part of that if they don't have good risk management tools to do so. So we need to do more with less, as you know from your community, and we're in a very difficult situation. So what I said at the outset, why in the world would this Congress or our government agencies sit back as somebody from another country is trying to take away the jurisdiction and create more uncertainty for the farmers of the United States versus the certainty they need? Because you know what? Sometimes you can't blame them for not wanting to tip their toes in the water, because if you don't know the rules of the road, you're not going to drive.
Well, I'll tell you, I think what we have to do in this committee and then broadly in this Congress is we have to prepare ourselves to direct ag policy in that direction with regard to utilizing these free market tools. In the end, that's the only thing that's going to be left available to farmers. If we don't get that right now, if we scare that out of the market, what are we left with? And farmers are behind the 8 ball and have been for quite some time. And so when we talk about this in the context of hedge funds and all the terms that we've heard use the sort of the industry vernacular, that creates even more discomfort, for lack of a better term, among the folks, the very folks that these markets were designed to help protect with regard to a risk management strategy. So as we move forward in that, I want to work with you on this, because I think we most definitely need to be incentivizing farmers to use these risk management tools. And this is a much more relevant question here in this committee, to advocate for farmers. I have nothing against hedge funds. I think they're important. They're important parts of the market. But at the very basis of this, the very basic level, if we get this wrong, we've done maybe irreparable damage to our farmers. And I appreciate your work on this and look forward to working with you going
Thank you,
forward.
sir, and I completely agree with you, but I will also say one thing. The sophistication of the American farmer on risk management is at an all-time high right now, and good for them. They're really doing an amazing job.
Thank you, and I yield back. Thank you, Chairman.
Thank you, Mr. Crawford. And now we recognize the gentleman from New York, Mr. Maloney.
Thank you, Mr. Chairman. I apologize for arriving late. I want to thank the witnesses for being here on this important subject, and I wouldn't have missed the first part of the hearing if I hadn't been shepherding a bill from my subcommittee on the Coast Guard through T&I this morning in a markup. But I appreciate the opportunity to be here. I appreciate the testimony you've all submitted. I am curious, Mr. Berger, from the buy-side perspective, and forgive me if some of these questions have been covered already, but from a buy-side perspective, could you elaborate on some of the harm from your perspective with the EU proposals?
So as I've noted in my testimony, MFA is a proponent of central clearing of derivatives. We think that central clearing mitigates systemic risk, increases investor protections, and provides for a more transparent and competitive marketplace. Our derivatives markets are global markets, and for buy-side market participants, we want to have the ability to conduct our investment activities, our hedging activities in the largest possible liquidity pools with the most diversity of other participants. That ensures we can get the best pricing, for the folks that we're investing on behalf of. And so that means that it's important for us to have access to CCPs, to clearinghouses, whether they're headquartered in Chicago, Atlanta, New York, London, Paris, or Frankfurt. And so it's essential for our members that regulators work together to use the tools of substituted compliance, deference, and equivalence to ensure that there is that access. And so taken to the extreme, the concern with the EMIR 2.2 proposal is that it would require the relocation of certain clearing activities exclusively to a certain jurisdiction, which would fragment that global liquidity pool that we all benefit from operating in.
I appreciate that. Mr. Duffy, you're certainly systemically important in the U.S. ESMA seems to want to give you that designation in Europe. Why do you think they want to do that?
Well, as I said earlier, Congressman, I think it's more of a regulatory grab, for lack of a better term. I think they are looking to become the regulators for the world, and when they want to deem, a systemically important institution like CME here in the United States and give us that same designation in the EU, and as I said earlier, roughly less than 5% of CME's products are euro-denominated, it's kind of a stretch to say that we're a threat to the European economy. So I think there's nothing else other than they want to have one set of rules, and they want the rest of the world to fit into their rules. And as we've heard earlier, they were testifying here in 2012 how that didn't work, but now all of a sudden that's the model they want to apply. So they want to deem us systemically important because of our designation here in the United States, and that it has no bearing whatsoever of what CME brings to the European Union.
Right. So as a proponent of central clearing, and believes it's one of the kind of wonders of the world, the fact is that some of us are also worried about clearinghouse risk. What are the risks that we should be worried about today in terms of your business?
Well, I mean, there's risk associated with everything we do, Congressman, as you well know. I think what we do is, when we're a neutral facilitator of risk management, so we do not participate in the markets.
Yeah, I understand your business model, sir, and I understand the role you play. What are the risks?
The risks are, if there's a major default by more than two of the biggest counterparties in the business. So if you had 2 or 3 major banks go down at the same time, that would be a risk not only to CME but to this entire financial system.
And what would happen in that scenario? What's
I don't even want to make a comment of what I think could happen, sir, because I don't think it would be very pretty.
And would the European approach to this be justified by those risk scenarios, or are those likely to be outside of their purview?
Well, if if I'm referring to U.S. entities, I'm not referring to Euro entities, so I'm referring to U.S. So I don't know what the Euros would have any say in that matter whatsoever.
So it wouldn't support their position that there might be systemic risk here, even if we were concerned about clearinghouse risk in the United States. Would it support their position in designating you systemically important?
No.
Right. Yield back, Mr. Chairman. Thanks.
Thank you very much. And now, General from Illinois, Mr. Bose. Thank you.
Thank you, Chairman. Mr. Duffy, when you closed out your testimony, you encouraged Congress and the CFT to consider whether additional regulatory and statutory tools might be useful or are necessary. As you know, the committee right now, we're preparing to reauthorize the commission again this year. That being said, as we do so, what remedies might, and I think this is what the chairman asked earlier, and I'd like to get into that, what remedies might be effective to protect U.S. markets and participants from ill effects of the EU's overreach?
Thank you, sir. And I think when you look at the reauthorization process, you can definitely implement new tools that the CFTC can have in their tool chest, as was referred to by Mr. Edmonds. I think what the U.S. Congress could do is a lot more aggressive than just on reauthorization, putting in things to the CFTC. I think the United States Congress, who does a lot with the European Union on a whole host of issues, should put this in their side of the ledger sheet, saying we need to make sure this is fixed. We have other big issues as it relates between the European Union and the United States. Let's deal with them, but we also have this issue, and we're not going to have duplicate regulation associated with our products by your people. We're not doing it to you, so don't do it to us. So I think there's something that the Congress can take to the next level, and I think that's exactly why, and I applaud the chairman for holding this hearing, because when the CFTC voted yesterday unanimously on a bipartisan way, and I'm hearing nothing but bipartisanship by this committee, this is what the Congress, I'm hopeful, will continue to do and send a very strong message to the European Union that we have a whole host of issues we have to deal with outside of financial services that we're dealing with you on, and then we're going to put financial services regulation in that bucket, so make sure you get this accomplished.
Thank you. And I'm letting you know that this committee is really in agreement with you. We're just wanting to make sure we're positioned correctly. Mr. Edmonds and Mr. Duffy and Mr. McGuire. Now, while all you operate clearinghouses that welcome participation from international clients, the mix of products that you clear is substantially different. Can you describe those differences as well as the differences in the regulatory and international coordination for these products, so we know the difference?
Well, I think if we were going to describe the differences in all of our products, we might need more than this hearing allows today.
Probably more than 5 minutes, too, correct?
Well, more than 5 minutes. I think I would sum it up for you this way, and happy to follow up with you offline if greater detail is needed. From an ICE perspective, when we look around the globe, we're not going to tell anyone how to trade, where to trade, or what to trade at the end of the day. What we want is the opportunity to earn your business when you make a decision to trade. So if you want to be in a certain regulatory jurisdiction, we provide services in that. Some people do, others don't. My colleagues up here who we compete head-to-head on a daily basis, they have slightly different philosophies from time to time. But once you get at the philosophical level, you're going to pick your jurisdiction as a customer. You're going to understand exactly how you're going to manage the risk that's most important to you and the business that you're running at that time. We want to give you all the tools necessary to do it within that jurisdiction. Slightly different perspective than others have. Both work, and that creates competition across the marketplace and ultimately benefits the consumer at the end of the day for having that choice.
If I may embellish, Congressman, the LCH group, I'll not, again, give you the full plateau of the products we clear and the differences, but I'll focus predominantly on interest rate swaps, which is really the preeminent service that we clear and are responsible for. The swaps market is very much a global market. It has active participants globally from many different jurisdictions, and these are tools, as referred to earlier, that are used for real economy hedging purposes. So that's the product that we have a material position in, and that product is traded globally and is overseen globally. So it's a slightly different fact pattern, sort of a slightly unique organization in that regard. So we have oversight through direct registration in many different jurisdictions, and we've worked through that over many, many years. As I mentioned in my testimony, we've been a registered DCO here in the States for 18 years. That's proven through the test of time, through Lehman Brothers, through MF Global, the coordination, not just at an operating level, but between the regulatory supervisory authorities of CFTC and Bank of England have operated well there. So we have a regulatory architecture that we sit within, which is maybe not the architecture you would apply for some of the futures markets. It's very much a global OTC market. So I think there's definitely a case here for different regulatory architectures for different types of markets and different types of products. That would be my main contribution.
If I may, sir, you know, CME Group is the largest exchange in the world, and it lists all the major asset classes that touch everyone's lives on a daily basis. So to give you an example how important this is, CME Group had 44% of the notional value of trade of the U.S. Treasury market 5 years ago. Today, CME has 118% of the notional value of trade of the U.S. debt market. So what does that mean? When you have inverted rates going on right now, when you have the rates that are happening in Germany and other parts of Europe, people are looking to invest in certain types of issuance, such as U.S. debt products. They're using CME to manage that risk. That is a very big deal for European participants to participate in the U.S. market, which, as you know, helps benefit us by running our economy, by selling our debt to them as well.
I wanted to say thank you to all of you. My time has expired. Thank you, Mr. Chairman. I yield back.
Thank you. And now, gentleman from Kansas, Mr. Marshall.
Thank you so much, Mr. Chairman. I think of my first question, I'm going to go with Mr. McGuire. Mr. McGuire, my farmers, my cattlemen, pork producers back home use this derivatives market a lot. And I've talked to hundreds of them. They say it's not broken. It's working fine. This committee and many of us as individuals have tried to understand the swaps and derivatives market, and I think it's going along great. When I study big picture analysis, I like to understand the culture of what's happening. I'm afraid the culture with the European Union is going the wrong direction. I feel like maybe they're being a bully. They won't let us do trade with agriculture in the next trade agreement, and this is another example, it feels like, of them pushing us around and taking advantage of Brexit. Tell me what's going on with the cultural relationship with the United States and the European Union through your eyes sitting there in London.
This could take longer than 4 minutes. I think we have, I guess, a unique position in the UK. We are exiting. We are now going to become a third country, much the same as the US. I think it sort of really echoes some of the points that have been raised already, in that there seems to be an increasing, I use that phrase again, I don't use it lightly, that arms race, where there are different incentives or different positions being taken maybe than there were historically. So, our position is that I think we need to take the temperature down. I think there were views historically that maybe in the first instance when we had the legislation after the crisis and the G20 commitment in 2009, Dodd-Frank went first, that sort of, the pendulum shifted one way, and I think there's a feeling now that Europe is shifting the pendulum the other way. I think we need to bring things back to more of an equilibrium, where actually, in the eventuality of this arms race continuing to escalate, what we're going to end up with is fragmentation, which is going to be a bad impact for all. So I think there's really a need to take the temperature down. It's hard for me to say, I'm not involved in the US-EU negotiations and discussions directly. It would be wrong for me to comment, but it does strike me that we need to sort of de-escalate rather than continue to escalate for the benefit of the end users that are involved here.
Okay. Next question. As the dollar, the euro, and then the British pound, as they fluctuate in values, does that give anybody any heartburn as we make this transition going forward? And maybe I'm worried about nothing.
I mean, there are always macroeconomic events at the end of the day that impact volatility as it relates to currency markets on any one of those sovereign nations that you make reference to in your question. I don't know that anything in what we're doing here is any different than what you see on a daily basis. There could be individuals that have an opinion and choose to express that opinion through risk management tools and trading the products that any of us offer at that moment in time based on their opinion of where a market is heading or isn't. But that's a moment in time decision they'll make, and they will either profit from that or they will lose.
All right, I'll go to Mr. Lucan next. If a CCP is faced with two regulators that are unwilling to defer to one another, is it possible that a foreign regulator, such as in the European Union, could impose requirements not for safety and soundness, but instead for competitive reasons? What does that look like? How would they take advantage of us on this, and how would it impact my farmers back home?
Well, that's what we're really trying to avoid here, is that type of duplicative situation. There has been situations in the past where two competing regulators have been talking to clearinghouses. I think LCH has had examples of this in the past during systemic events. And thankfully, during those times, one regulator deferred to the other, and they were allowed to do what was in the best interest of the clearinghouse. I think, these are the things that regulators need to work out now. This is a level, it comes down to, as much as we can paper this with agreements, it comes down to trust. And for some reason right now, there is a lack of trust between the Europeans and the United States that we're trying to figure out how do we get back to that level of cooperation that has existed for a long period of time between our two jurisdictions. So, our hope is, and EMIR has the capability of the Europeans recognizing the 2016 equivalence agreement and agreeing to defer to U.S. regulation. And I hope they take that common sense approach so that we avoid the situation that you're talking about.
Mr. Duffy, I just got a second left. CMA's been around a while, great reputation. How do you see this cultural, is this something new or just another chapter of this relationship with the EU?
I think it's a bit of another chapter, and we have been around 175 years, so you're right, a long time. I don't think that, I really believe people want to do the right thing, sir, to be honest with you. And I think people understand that there's a regulatory regime and it's not a one-size-fits-all, and we can all get along together and operate in a global marketplace, because that's truly what it is today. It's not a centric marketplace. It's grown exponentially, and it's benefited everybody. And I think when cooler heads prevail, so the good people that you represent will be able to sell their products internationally without somebody maybe manipulating their currency to avoid a tariff, things of that nature. Those are all big, big issues that this Congress needs to address. But I don't believe that the European Union is doing anything other than when you look at what happened in 2010 with Dodd-Frank, when you create new legislation, the pendulum always goes to a certain way, and it did it in 2003 with Sarbanes-Oxley. It doesn't make it wrong, because you could always walk it back. It's hard to walk it forward. So I think what's going on right now is you're seeing the same thing happening in Europe, and I think they're going for a little bit of an overreach right now. And I think just alone with the Congress being involved, you could walk them back to where they need to be.
Great insight, thank you. Mr. Chairman, and I yield back.
Thank you. And now we'll hear from the gentleman from Florida, Mr. Nunn.
Thank you very much, Mr. Chairman. I think we all see the problems and the risks in the proposed EU regulations. I want to highlight several of those problems. Mr. Duffy, EMIR 2.2 proposal does not provide ESMA with oversight over European clearinghouses. Rather, it defers oversight to what they recognize as competent national regulators in the EU member states. But that does make ESMA in the space of clearinghouse oversight an international regulator focused really only on the third country clearinghouses. And while that's strange enough, the proposal also envisions fees on these third country CCPs would cover the entire cost of this activity. It means the CCP in the United States, for example, would pay for the privilege of being regulated by a foreign entity and pay handsomely indeed. I believe that that's an egregiously bad infringement on U.S. sovereignty, and you said earlier in your testimony a crime under U.S. law. If we're honest with ourselves, I think this entire regulatory exercise is an attempt to punish the U.K. for Brexit and to ensure that the punishment is so severe that subsequent members will never attempt to leave the Union. Because ESMA's proposal caps the fees on Tier 1 CCPs and divides the cost of their ESMA's clearinghouse oversight budget between all the Tier 2s, and they designate who is a Tier 2, does that not seem to incentivize them to designate more CCPs as Tier 2 in order to expand their staff, build their regulatory footprint, a sin we frequently see in bureaucracies?
Spot on, sir. I mean, that's all I can say is spot on. When you're talking about a proposal that doesn't even charge the local entities for their own regulatory cost, and they want other parts of the world to pay for it for them that are not even systemically important to that part of the union in order to do business, it doesn't pass the ha-ha test, as they say in the business. So I think you're spot on with the fee issue, and it's really a shame what the European Union is trying to do right now.
Thank you very much. Mr. Lucan, your testimony contains a chart detailing the cross-border activity that occurs at several of the FIA's membership. If I'm reading it correctly, it looks like the Eurex has well over 50% of its transactions originating outside its home jurisdiction. I would like a sense from you, either now or in writing later, of what those percentages represent in a dollar value, and what percent of the overall business in the European CCPs is dollar-denominated derivatives and futures originating in the United States. Also, if we're threatening the concept of equivalence between the United States and Europe, what does that impact look like on European exchanges? And I ask that because the U.S. is unlikely to cede regulatory authority or sovereignty to the EU. And in that case, are the EU regulators really willing to walk away entirely from any access to U.S. derivatives in future? Are they willing to give up all access to American markets for swaps and hedges? That looks like that's what's on the table.
Yeah, no, it is exactly what we were trying to portray in that chart, is all of these global exchanges require, in order to have the proper liquidity to serve domestic markets, they need foreign participation. And Eurex is one example where they get a significant amount of their trades from outside of Germany. A lot of it may be coming from the UK, a lot of it's coming from the United States. But again, if any of these proposals end up causing a loss of access to either Europe or the United States, that harms everybody. And that's what we're trying to say is we really need to be sensible about this. Open markets benefit everybody. All boats rise.
It hurts our ability to manage the risk, right?
Absolutely, absolutely.
So my time is growing short, but I want to say that it seems like to me there are no winners in failing to provide equivalence where equivalence is clearly due. And I believe that the U.S. should use, and the Congress should use any leverage necessary to ensure that we do not get stuck with a raw deal. In the meantime, I think Congress should request or even demand that the European regulators come before Congress and explain to us how this is going to work and why we should allow this regulatory invasion of the United States. And with that, Mr. Chairman, I yield back.
Well, certainly, we appreciate that, and we will move forthrightly on that. I agree with you. As a matter of fact, the ranking member and I were just talking about the next steps we need to take, but I assure you there will be a very strong and adequate response for this. We're not going to put and make our financial service industry be turned into second-class citizens on the world financial stage. You can bet that. Thank you, sir. Now we'll hear from Mr. Johnson.
Thank you, Mr. Chairman, and I'll have some questions for Mr. Lucan. I think picking up thematically on the lines of questioning from Mr. Marshall and Mr. Dunn, and it seems, as I've heard everybody speak today, it seems as though we've got a shared understanding of the value of the 2016 equivalence agreement. It seems like we have a shared concern about EU efforts to pull back or perhaps complicate that system of regulatory deference. And I'm surprised by that because it seems as though the fundamental landscape is the same as it was in 2016, save for one thing, and that is a pretty substantial member default, and I think a concerning response at a European CCP regulated under the EMIR framework. And so I think my first question for you, Mr. Lucan, I mean, FIA has a wide cross-section of market participants, including a number in Europe. What were your thoughts or the thoughts of your company when you saw this pretty substantial failure?
Well, I think there was significant concern among the entire industry and a lot of soul-searching among even panelists up here on what went wrong during the NASDAQ default. And as you mentioned, they appeared to be EMIR compliant, that entity, and they're owned by the NASDAQ Corporation, the holding company here in the United States. And we did a review of that default and have recommendations. NASDAQ, to its credit, has also done an internal, hired outside consultants to help it to identify what went wrong. So even though you can be in regulatory compliance, that doesn't absolve you from active risk management. And I think these clearinghouses can talk about this, that even though on paper you may be compliant, there is an active daily risk management that has to be carefully considered. And for whatever reason, the NASDAQ had, especially as it gained new members, individual members of the clearinghouse, may have let in more risk than that was appropriate. So it was something concerning to us.
Well, and I certainly understand that it's hard to be a perfect safety and soundness regulator, right? I mean, there is risk inherent in the system. But as we sit here today talking about a potential pretty substantial shift of that safety and soundness being evaluated in this country to being evaluated in the EU, I have to be left with the question, is there any reason to believe they're very good at it? I mean, if they missed the warning signs that led up to this, again, pretty decent-sized failure, should we doubt the prudence of the European regulators?
I think it is a very good question. Here is ESMA deferring to the National Competent Authority of the NASDAQ of Sweden in this situation, but not directly regulating that CCP. That's the way the EU law is written. But I think it does raise a question that if you're not regulating your own CCPs, why should you be regulating outside CCPs? That's the way the law is written. But I do think fundamentally, philosophically, it raises a good concern and question.
So were there, thank goodness we didn't have a serious contagion problem in the wake of that. Were there components or fact sets within this environment that kept the ripple impact to the, I don't want to call it modest, but to the non-systemic level that we had?
Well, I would say that clearing worked, and one of the reasons the G20 recommended clearing as a safety net for our markets is it has several layers of its waterfall of clearinghouses that ensure that a default does not have contagion risk. Unfortunately, it got pretty far down into the waterfall, including into the guarantee fund, and took down about 2/3 of the guarantee fund. But it quickly recovered, and members, put more money into the guarantee fund, and clearing worked. That doesn't mean we shouldn't use that example, though, to see what the lessons learned might be, and we're in the midst of doing that.
So, my understanding is it was in the third tier of that waterfall you described. It had the entirety of that default fund been exhausted. Is there a fourth level to the waterfall?
CCPs have the ability to assess clearing members again, to replenish the guarantee fund, and certainly that would have occurred. This was not a major size clearing organization like the ones here, and I think the clearing members would have done so. But still, if you extrapolate that to larger clearing houses, it's problematic, and we want to make sure that whatever problems existed there, that we as an industry try to address those things.
Yeah. Particularly if you have a couple of problems happen during the same time period. You start to exhaust these management mechanisms pretty quickly. Thank you very much, Mr. Lucan. Thank you very much, Mr. Chair. I yield back.
Now we will hear from the gentleman from Indiana, Mr. Baird. And I might mention, in case any of you may not know, the ranking member and I have decided we'll have just a short second round so we can come back and put some final touches to this. So if you want to hang around and have a second point, you certainly can. Mr. Baird, you're recognized.
Thank you, Mr. Chair, and I certainly appreciate the comments from some of my colleagues about agriculture and the livestock industry and farmers and ranchers. And Mr. Duffy, I really appreciate you recognizing the importance of agriculture in the CME. But my question, Mr. Edmonds, deals with some background for you. They've held a hearing here on the clearinghouse recovery and resolution last year. One thing we learned is that the certainty about the rights and obligations of affected parties and clarity about who is in control is essential to managing the crisis and restoring order. In your testimony, you briefly discussed the challenges of overlapping regulators during a time of crisis. So while no one expects a clearinghouse failure, if there was a failure at a non-European Tier 2 CCP that was not extended as substituted compliance, is it clear exactly which regulator would be in charge?
As we answer the question today, I think it's difficult for us to say with absolute certainty who would be in charge at that point in time. As Mr. Duffy said, if it were CME Group that found itself in that, there would be problems with the U.S. law here. I mean, certainly we have clearinghouse operations around the world that we would also have local national regulators at the time having that concern at that moment, wanting to weigh in. So the one word that keeps coming up, and many of us have touched on it here, and really at the epicenter of the issue is whether or not we are creating certainty. And the less certainty we have, or the more uncertainty we create, that's where you begin to see all of the questions in the waterfall of what you might determine bad things happening. Whether it's inside the clearinghouse, there's a lack of certainty when these things take place. Whether it's in the market, the lack of certainty creates volatility. Sometimes that's good and means that, people on the right side of that. Other times, if it's overwhelming, like we saw in the financial crisis of the uncertainty, it's really bad for national economic policy or international economic policy at the time. So I can't answer your question with absolute certainty if we would at that time of stress. I think, as Mr. Lucan has said, we all want to avoid that. We're all committed to finding ways through that, and if we weren't, we wouldn't be sitting here today and wouldn't be taking the stances we do on the international stage to attempt to drive to that certainty. The worst thing that we can do is wake up and have a customer call us on any one of our venues and say at a given moment in time, what is the answer to this question, and not be able to give them a complete answer. And right now, I think as a whole, until some of the arms race, as Mr. McGuire has articulated, settles a bit, we're faced with that issue of having an incomplete answer.
Thank you. Anyone else care to comment on that question? Okay, my next question goes to Mr. McGuire. You're registered with the CFTC and the same as any U.S.-based clearinghouse, and yet you're domiciled in the United Kingdom. So can you describe to me how that relationship between LCH, the CFTC, and the UK regulators works?
Sure, thank you for the question, Congressman. I think the way I describe it simply, it works well. I think the relationships are, you need to think things through, let's say, sunny day scenarios and rainy day scenarios, and the sunny day is business as usual and there's no major defaults or crises, and the rainy days are crises or defaults such as Lehman or MF Global. And over the course of 18 years, with those events, and also with the enactment of Dodd-Frank and European regulation and other regulation around the globe, we've always found a way between LCH with the Bank of England, who is the primary regulator in the UK, and the CFTC, who have oversight as well, to navigate through any of those legal or regulatory texts and always arrived at a sensible outcome. So that has enabled us to be 100% compliant with all of the DCO core principles here in the US. We are fully compliant with and our clients benefit from the client asset protection rules and Part 190 bankruptcy code here in the US. We hold assets onshore. So I think it's a way to show that it is possible to navigate where you are systemically important to a jurisdiction, which we clearly are in this case. It is possible to achieve it. But I think the main point I would say is that the key to that is trust. The key to that is cooperation. The key to that is deference between the regulators and constant communication and transparency.
Thank you. And I'm running out of time, so I yield back, Mr. Chair.
Thank you very much. As I mentioned, the ranking member and I have a few more questions, and you may as well, Mr. Baird. But let me get to the heart of the matter. And the heart of the matter is, quite honestly, we've got a problem here. There's no getting around it. I think in each of your testimonies you pointed that. And so we want to try to find out, what do we do about it? And judging from what I'm hearing and for what we've heard, I can assure you that we in this committee, myself and ranking member, are prepared to move on some action to very quickly and decisively get a message to the European Union in a proper way. And secondly, we need to devise a way in which we can use our leverage to respond to this. We are the strongest, most powerful, and fairest economy and financial system in the world. And the European Union is really messing with the wrong tiger here. And we need to get that message out. Because if we don't, for example, this whole EMIR situation is wrong so many ways. First of all, setting up a way in which you all become, or we become, what is affectionately called third countries. What does all that mean? Why? And then Great Britain is thrown in with that. And between the United States and Great Britain, we are the two largest, most significant financial systems. And they are operating in a very haphazard and dangerous way to themselves. We need to get that out. We also need to examine how we offer some form of retaliation? Do we pull back our market to them? We have the largest, so we have to think very seriously how we use our leverage. I hope we don't have to go there, but we got to send that message. And so what I want to do with this period is to hear from you and each of you in terms of what specifically you all would recommend that we here in Congress do. And the incubator of this action will be our subcommittee, because this is our territory. We have an excellent staff. The full bipartisanship of this committee is ready to spring into action quickly and decisively to do something. What that something is, we need to discuss and come to some decision very quickly onto what it is we need to do to make sure that our financial system, our market participants, are not put at a disadvantage on the world stage at this time or at any time. That's what I want to try to get to at this point. And may I please start with you, Mr. Duffy, on what it is you think we can do to address this problem with the European Union right now.
So I appreciate that, Mr. Chairman, and as we've been talking about, I think you've already done a lot more than anybody else has done historically, just by holding this hearing and giving it the time and attention it so deserves. So that is greatly appreciated, and it's been so bipartisan. As I said earlier, it's a very powerful message when the United States Congress gets involved, not just the regulator. So I am very much appreciative of that, and I know the industry is as well. I want to go back to what one of your colleagues said earlier, that the UK is the bully. I don't believe the UK is the bully, nor is Mr. Maguire. I think Mr. Maguire and the UK are in the same situation as the US is right now. The EU is trying to show their dominance throughout this process on the Brexit, and that's part of what this hearing's about, and they're using the U.S. as part of their leverage against the U.K. So I don't believe they're the bully. As you said earlier, I think they are a very powerful economy, and they're going to maintain that. What Mr. Lucan said earlier is critically important, and I hope everybody reminded the statistics he gave. 70% of the German bond is traded outside of Germany. And if you really want to get to the heart of the matter, you get the German authorities in here and ask them what they think they're doing with their European counterparts in order to drive this regulation. Because if you take the liquidity out of the German bond, that will cripple their economy to a degree. And if that liquidity going into that bond is coming out of the UK and the US, which I believe a good chunk of it's coming out of the US, and you limit that, that would be a very powerful statement to limit that type of activity. Now, is that a good thing? No, absolutely not. But if they're going to go down this path, we have to also understand that we can just as well by doing it through the Part 30 process.
Thank you very much, Ms. Edmonds.
Look, I think you have a multitude of options and probably know better, certainly better than I do and maybe better than the rest of us on the panel, of all the levers you have to pull. So I'm going to talk to you a little bit about when you pull those levers, whatever they may, how they're perceived on the other side. You've heard us all talk about certainty, and anything that you can do to increase certainty I think is an absolute must, and you should find great favor in it when you're drafting whatever response you deem is appropriate and proportionate to make sure that it is promoting certainty. I think you should promote equivalence. We've taken a lead on this as a country. I don't know, on the regulatory side, I'm not exactly sure the benefit of us going a different direction in the leadership we've shown to date.
You did say
equivalence.
Equivalence.
Right. That is correct. So if we're providing a framework and supporting other frameworks that provide that level of deference through the equivalence process, and we're providing certainty along the way, I think what you're doing is the benefit for the marketplace as a whole to be able to operate within a set of rules in order to manage the businesses they have, no matter where they are, from a hedge fund down to a farmer and everyone in between that you want to get to that have a critical function to play within our market system as a whole. Mm-hmm. And then if you don't get what you're looking for there, you got to be prepared to act. And those are the levers that you're going to know better than we are exactly what's best. This is not a binary decision that you're going to make, whichever one. There are going to be other other actions and reactions to whatever you decide to do. And I think you have to look at that holistically, and you have a much better point of view or a vision of that than we're going to be able to see, because we're going to take your action and we're going to have to react to it, whatever that is. And we're going to have to change parts of our business, whether it's in London, whether it's in Chicago, or anywhere else here in the United States, in order to continue to provide for our customers. That's our job at the end of the day, is to get through all of it at the end of the day and give them some level that they can continue to manage their business within the confines of that regulatory framework. So I think the more, just to reiterate, the more that you can promote equivalence, the more you can promote certainty from that equivalence, and that being that leader by example, I think we get to a better place at the end of the day.
All right. Mr. McGuire, yes.
Thank you, Chairman. I make two remarks to your request. In the first instance, I'd just point to the long-established and well-working relationship between both the US and the UK financial systems and markets, and I would hold those up as the epitome of something that works and works well, and it works well in, to repeat what I said earlier, sunny days and rainy days, and good times and bad times. And I think it's important to lean on that when we talk about how equivalence and deference can work around the globe from financial markets. We have a model in place between the UK authorities and the US authorities for overseeing the firm that I lead. It works well, and I think that should be held up as a model, and I think it should be used as a artifact in explaining how things could and should work and do work. I think the second remark I would make is that when we talk around Tier 2, which has been referred to, it's a slight technical point in EMIR 2.2, right now things are in, let's say, a ambiguous state. There is a full range of tools available to the European authorities in the bucket of Tier 2. And it's really expected to be a continuum of either Tier 2 heavy oversight versus Tier 2 light oversight. But what's lacking, and what makes us all nervous and gives us that lack of certainty and clarity that Mr. Edmonds refers to, is there is no definition or precision around that. So I think the sooner there's more precision and definition of what Tier 2 means, what it means for each firm, what the kind of oversight that could potentially mean, I think that could very much help bring the temperature down here on how things are looked at from the third countries. But right now, absent that clarity and certainty, it's difficult. And key point being that determination of level 2 tiering is likely to commence towards the back end of this year and into Q1 2020. So the time, I would say, is opportune to request that level of specificity and definition.
Okay, thank you. And Mr. Lucan.
Thank you, Mr. Chairman. I think the most powerful tool that this committee has at the moment is its oversight function, this hearing being a part of that. There is an open comment period right now in Europe on EMIR 2.2. I would be sending a letter to those the ESMA agency, and with the record of this hearing as part of that comment period, so they understand what the view of Congress is and the view of the United States might be on this topic. You certainly have the ability through your oversight to make sure that it is clear that there'll be collateral damage as a result of this EMIR 2.2 if the United States is not recognized as part of that regulation. I do want to make clear, though, on one of the issues that the Europeans have raised with us when we see them is that the CFTC over time, and this dates back to Dodd-Frank, has laws and regulations in place that regulate and require the registration of foreign CCPs. Now, the current chairman has said he wants to walk that back, and he wants to propose something very soon that would put in place a recognition regime like we're talking about. We have, because of the transition to the new chairman, that has not occurred yet. But I would give this new chairman some breathing room to try to negotiate with the Europeans to get them to make the right choice. It reminds me of my parents. They would tell me you have two choices, choice one and the right choice. This committee can be very effective at making sure that they're making the right choice on this and allowing the new chairman to come in and help us to get us to that place.
Now, you said a letter. What would be the most emphatic points that we need to make within that letter? And I think you also mentioned, did you not, that we would send them this hearing in and of itself. And
This is part of the public record, this
Right.
hearing here, and, and our testimony is part of the public record. They are they're in the midst of a consultation, and just like any public record, this is an important factor that should be a part of their determination. So, whatever cover letter you'd like to summarize the hearing here and your views, that includes the entire record of this hearing, I think would be important.
And you're saying within the European Union, who specifically, you mentioned the...
ESMA right now is
ESMA.
the agency that is holding, it has an open consultation period right now for this regulation.
All right. Good. All right. Thank you. Yes. Mr. Berger.
Thank you. The U.S. has a robust framework for the regulation and supervision of our clearinghouses, and that's what helps make the U.S. markets the most deep, liquid, and efficient markets in the world. And as market participants who are active on all the clearinghouses that are represented here, MFA members don't trust that blindly. We remain vigilant. We care about the governance and risk management practices at all CCPs that we participate on, and sometimes, comment on those to even enhance them further. To pick up on the points that Mr. Lucan just made, where we stand right now in the European process is they are evaluating how they approach two decisions. One is how they evaluate which foreign or non-EU CCPs they deem to be systemically important, and then if they make that decision that they're a systemically important or Tier 2 CCP, then the next step is how do they evaluate whether the framework in that other jurisdiction is comparable, so they call it comparable compliance. And so I suspect everyone up here will be weighing in with advice on how they take those next steps in the process. So EMIR 2.2 is now a piece of legislation, but the implementing rules are still under development. So I still think there is ample opportunity for our voices to be heard, and your leadership in bringing attention to these important points will, I think, help amplify the voices that are providing advice to ESMA as they consider the next steps here.
Thank you. And now we'll recognize and hear from the ranking member, Mr. Scott.
Thank you, Mr. Chairman. And I want to go back again to some of the statements I made earlier. We share common interests and common values, and we need each other. And while we need each other now for economic growth, we will need each other more in the case of a financial crisis in any one of the countries or regions that we're talking about. And so the best path forward to me is very clear, to take a couple of steps back. Let's take a look at what Commissioner Giancarlo or the new commissioner of the CFTC would put out, and hopefully no additional steps would be necessary from this committee to achieve global harmonization. But with that said, while I prefer to take a couple of steps back and end up with that harmonization from the regulatory agencies, if necessary, I stand prepared to move forward with my colleague, Chairman Scott, as I believe the full Ag Committee would be if necessary, to make sure that we achieve that global harmonization. But again, I do believe the best path forward is to take everybody take a couple of steps back and recognize that we need each other. We've talked about, and this gets to my question, we've talked about the transactions, if you will, but one of the things we haven't talked about much is the technology. And this question is for you, Mr. Lucan, because you mentioned it specifically with regard to FinTech and the R&D capabilities. You talked about the emergence of the importance of the emerging financial technology. You talked a little bit about legislation that this committee, including myself, has been working on. Can you speak to why it is so important that U.S. regulators and quite honestly, global regulators are able to stay abreast of the latest financial technologies and keep up with the capabilities both for the U.S. and for foreign regulators?
FIA is a trade association oftentimes have conferences, and we have oftentimes new innovators. We call it Innovators Pavilion, where we ask for the latest technology being developed. Oftentimes it's on the private sector trading side, but oftentimes it's on the reg tech side. So it's giving us technology on how you surveil the markets, making sure that traders aren't trading ahead or doing illegal activity, or if risk is building up in the system. All these CCPs around this table have private companies that are helping them to manage the risk of their exchanges. You have shown some leadership on this and have introduced some legislation that would allow the CFTC to partner with private sector financial firms to allow them to utilize some of this technology in a fair way, in a transparent way, so that currently the CFTC is not allowed, because this would be a private inurement to the CFTC, and governments can't receive gifts. So this would be an exception. Right now, the Defense Department allows this sort of partnership arrangement. A lot of the EU and the UK allows this type of partnership arrangement. So as a former commissioner and chairman of the CFTC, having access to that kind of technology would be tremendous in a way that will better the markets, further the public interest. So we as an agency, or we as the FIA, certainly support this initiative that you've put forward.
And let me say, as one of the authors of the legislation, we recognize the word gift can be misconstrued. If there's a way to change that definition to relieve any concerns that some individual is actually receiving something of monetary value, because that is clearly not the intention of the legislation, then we're happy to work to find the definitions that resolve in any of those questions. But the goal is simply to allow our regulators to see and work within that technology so that they understand what's actually happening in the technological side of the market and the trades. And so thank you for your comments, Chairman. Thank you for your leadership on this. As I said, I think the best path forward is a step back, but if necessary, I am perfectly willing to work with you to push ahead with legislation. With that, I yield the remainder of my time.
Thank you very much, Ranking Member. Mr. Barrett, anything? Okay. Yes, sir, Mr. Duffy. Yeah.
I'm so sorry, but may I make a comment?
Sure, please.
I'd be remiss if I walked out of here without making this comment, because I really feel passionate about this. I understand what the ranking member said about taking a step back, and I understand what Mr. Lucan said about giving the new chairman an opportunity to deal with this issue. The new chairman has a lot on his plate other than just dealing with equivalence about running this government agency. So I think having the confidence of the United States Congress working with him is a very powerful tool that he would embrace, and I don't think he would shun it away. I also want to talk a little bit about the timing. As you know, the MIR 2.2 has already been agreed upon by the European Union. Also, I think it'd be critically important for this Congress to send a very strong message that you do not move forward any further until our answers have been addressed and our concerns have been recognized. Because I think when Mr. McGuire referenced Tier 2 under EMIR 2.0, I don't know if everybody realizes what that means. They're talking about having the ability to set margins on products here in the United States. So you tell me what they know about the livestock market that your colleagues talked about. You tell me what they know about the risk management of these products and how they're going to set the margins that won't put the U.S. at risk. They're also going to charge fees, as we discussed earlier, to fund their own agencies. They're also going to have the ability to fine CCPs up to 30% of their revenue, unilaterally, whatever they want to do. They also get to decide the governance of these entities, which is in direct conflict with Delaware law as public companies. And as far as it goes with the regulation by the U.S. on the EU or on the UK, and we do not regulate their base futures and options business. What Mr. Lucan was referring to is swaps. We have a very light touch on anything that relates to futures and options. They want to regulate our entire business, not just what our government is doing with them right now on the swap side. So I think there is some major differences here, and I applaud you again, Mr. Chairman, this committee for taking this up. Thank you for allowing me time.
Thank you so very much. And as we conclude, let me just say this, that I feel very strongly about this, And we're going to take the results of this hearing and all of our remarks and concerns. We're going to take it to the full committee, Chairman and Ranking Member Chairman Peterson, and as well as Ranking Member Conaway. And I am going to be pushing very hard to hopefully convince them that we need to take a step. We need to send a message to the European Union. I think the least we can do is your recommendation, Mr. Lucan, that they make sure. We love C-SPAN. It would be wonderful if they were watching this